FM. The future is now. High Impact Radio 102.1 FM. The future is now.
Where every word matters on High Impact 102.1 FM. Don't forget that you can also watch us live on Nikonsat 42 Degree East. We're live on YouTube, Facebook, and on X at High Impact 102.1 FM. I am Olumide Shokoya. On the program, we discuss actions and actions of government, ministries, departments, and agencies, as well as business and health affairs that shape our worldview. The program also encapsulates personalities and institutions that make decisions that affect the lives of the people, one way or the other. And of course, we avail you, our listener, the opportunity of calling into the program and ask questions from our guest on the topic of discussion for the day. Once again, welcome to On Record, where every word matters. The Economic and Financial Crimes Commission, EFCC, has denied allegations of assaulting lawyers who protested the detention of their colleague, Philip Ojo, at the EFCC's Ibadan office. The EFCC maintains that it did not use force against the protesting lawyers. The lawyers had gathered to demand Ojo's release, and their efforts were successful as he was later released. Now, the swift release of Ojo following the protest underscores the importance of collective action and legal community in protecting its members' rights. Now, the circumstances surrounding Ojo's detention are unclear, but it is believed that it is related to a lawsuit alleging human rights violation against an EFCC official. Now, the incident highlights the need for transparency and accountability in the actions of law enforcement agencies like the Economic and Financial Crimes Commission, EFCC. The phone line will be open shortly, 0700 1021 1021, 0700 1021 1021. In the meantime, you can also send WhatsApp messages to 0907 224 5018, 0907 224 5018. We are live on YouTube, X, formerly known as Twitter, and Facebook at High Impact 102.1 FM. You can also watch us live on Nikonsat 42 Degree East. So we take a breather here now and return to begin the conversation. Please stay tuned.
Welcome to the high side of Join us every day at High Impact 102.1 FM, your urban lifestyle station.
Money, I just want to be high.
Do you know bad production can kill a great content idea?
Do you want to have a photo shoot, audio production, or do you need a professional voiceover artist?
Do you simply want unmatched cinematography, video production, or just event coverage, such as weddings, birthdays, or burials?
Or do you need a space for meetings or conferences? All these are possible with High Impact Studios. Don't bring down your creativity, let's help you take it high.
And out of this world with our state-of-the-art equipment and first-class studio space.
We give you the quality you deserve at the best rate.
For more details, call 0706 393 5694 or 0915 958 1881. High Impact Studios, the future.
Tease your taste buds from a world of delectable choices. High Impact Planet. Fun just got real.
Impact Radio 102.1 FM. The future is now.
On record where every word matters on High Impact 102.1 FM, I am Olumide Shokoya. You can also watch us live on TV on Iconsat 42 Degree East. We're also live on YouTube, Facebook, and on X, following us as Twitter at High Impact 102.1 FM. The phone line is open 0700 1021 1021 0700 1021 1021, or you can send WhatsApp messages to 0907 224 5018 0907 224 5018. The topic for today is the unlawful detention and abuse of power in Nigeria. We're taking a closer look at the EFCC's denial of assault allegations. And joining us via phone call is Bolanle Ulugbani, a legal practitioner. Good morning and welcome to the program.
Good morning.
Thank you for joining us. All right.
Thank you.
Yes. So, of course, you're well aware of what happened during the protest, the lawyers and all that, and the whole thing that happened, the allegations being thrown here and there. But let's start off. What are the legal implications of the EFCC's action in detaining a lawyer? And were the rights violated? I know. It sounds funny because when you're being detained, it's a lawyer who comes to solicit for you. Now a lawyer is being detained. So, what are the legal implications to this? And were their rights violated?
Well, the arrest of any Nigerian is allowed for under the Police Act, the Penal Code, which is the criminal law of the North. The criminal code, which is the criminal law of the South, and the penal code, which is the criminal law of the North. The Constitution also empowers law enforcement agencies to be able to arrest to prevent the commission of a crime, or to arrest to stop the commission of a crime.
Yes.
So, but Section 36 of the 1999 Constitution says that every citizen who is alleged to have committed a crime must be presumed innocent until proven guilty. He must be availed the services of a lawyer. He must also be allowed to prepare his own defense and cross-examine his accusers. In addition to that, the law stipulates that anyone held for or suspected to have committed an offense which is not a capital offense, like terrorism, kidnapping, armed robbery, murder, should be taken to the nearest court within a 60-kilometer radius within 2 days. And the maximum period for which a person not having been alleged to have committed a capital offense can be detained is a maximum of 48 hours, by which time the police will decide whether to take that person to court or to admit that person to administrative bail on condition of providing a surety or some kind of arrangement that ensures that whenever it's required for further investigation, he comes to the police station. Now, a lawyer is a Nigerian citizen.
Yes.
And lawyers, by the nature of their profession and the oath to which they have sworn as officers of the Supreme Court of the Federal Republic of Nigeria, are presumed to be law-abiding and above board. So for a law enforcement agency, whether it's the EFCC, ICPC, the Nigeria Police, NDLEA, all those agencies and the authorities with powers to prosecute, to arrest a lawyer, it cannot and should not be for flimsy reasons. It cannot be and should not be for political reasons. It cannot be and should not be for emotional, sentimental, or reasons that are connected to the fact that the lawyer's duties to his client are causing an irritation to the law enforcement agencies or the law enforcement authorities. So that it is not usual, it is not common, it ought not to be that a lawyer ought to be arrested. And if a lawyer is arrested, I hope that the law enforcement agency that, arrests that lawyer would have, gotten prima facie evidence to justify the arrest.
All right.
Because what's going to come after the arrest of the lawyer is something with heavy legal implications.
All right, now let's go deeper into this. Now, according to the Punch, details of why Ojo was detained, well, it's still sketchy, but it was learned that it had to do with a fundamental rights suit against a yet-to-be-identified official of the EFCC. Now, in a telephone conversation with one of the persons, one of the protesting lawyer, that's Adedeji Falujo, he said that the officer who was being sued alleged that there were untrue facts contained in the suit. Now, he asked the lawyer, both Ojo and the bailiff, to write a statement concerning the alleged falsified information in the suit. Now, according to him, Ojo, that's the lawyer, refused to write the statement and was detained. Now, let's look at the legal implication. Is this legally right to detain a person? Because I mean, a common Nigerian is being told that you must not write a statement under duress. You must not be compelled to write a statement. So is this legally right? And what are the implications for this kind of scenario?
Well, first of all, once a matter has been taken to court, as in this case, the fundamental rights suit has been filed against an EFCC officer or even the EFCC itself, the matter becomes sub judice. That is, it is now under the jurisdiction of the court. And it is not dependent on whether the alleged defendants, or respondents claim to be aware or not aware of the suit. Once it has been brought to your notice, the fundamental principle of law, that tendency of the court action has as a stay on all parties. The case of Odumegu Ojukwu versus the Lagos State government. So it ought not to be an issue for you to be the accuser, the judge, and the executioner in your own case. If they are alleged misleading or false facts alleged in the suit against the EFCC official or even the EFCC, it is a matter that the EFCC ought to tackle by filing a defense or a counter affidavit to the alleged false fact in the suit and letting the court determine, the authenticity or validity or rightness or wrongness of whatever it is that has been alleged. No person can or should take the law into his hands when he has been sued to court, by arresting the person who has sued you. If somebody has sued, if Mr. A has sued Mr. B to court, and because you feel that what Mr. A did to you was wrong, Mr. B takes a gun and shoots him, that's the person is actually compounding the issue. And this type of act by the EFCC official is contemptuous. It is a contempt, not in the face of the court, contempt ex facie curia for a court to have assumed jurisdiction, and for you to be taking the law into your own hands. It means that you think you are in contempt of the court. You do not regard or respect the court, and as a result of that, you think that you have a higher authority or a power that supersedes that of the court, thereby usurping the function of the court which you are now before. So there are implications to it, and I think it's an abuse of power or ignorance on the part of that EFCC official or authority, as alleged.
All right, we're still coming to the court, but let's look at the lawyer-client relationship. How do you think this EFCC's action, I mean, you can imagine if a lawyer who I consulted to defend me, to solicit for me, is being detained. So how would this affect, the lawyer-client relationship and the administration of justice?
Well, of course, once you arrest the lawyer representing a party in a suit, the implication is that, one, that act is meant to frustrate justice being given to the person who has sued. The second is that by doing so, one is tending or intending to arrange the outcome of the suit in court and perhaps overreach in such a manner that that later action of arresting the legal practitioner will force a fait accompli on the court. That is, tie the hand of the court in such a manner that if you take an action, further action after a suit has been filed, you may want to make whatever the court wants to do totally irrelevant, unnecessary, and in fact impotent. So these are the implications, and in doing so, there are sanctions for it. Sanctions including ordering the arrest of the officer or the head of the agency or authority that has done so. There are orders of the court. They have to do with apology, and in fact, hefty damages may be awarded against that officer personally, and indeed authority that has overreached and tried to usurp the function of the court by abusing its power when a matter has been filed before the court.
All right. So, of course, you just mentioned a whole lot, but let's now go to the court. You said that once a lawsuit has been established in the court, it falls under the court's jurisdiction, which means you cannot just take laws into your hands and all that. But in the past years, in the past administration, we've seen absolute disobedience of court orders. I mean, I'm sure you witnessed what happened during the time of Showere's court case, whereby a DSS in broad daylight, this was filmed, where a DSS official entered the court to arrest and pick up Showere in the court. So how can we reform? Let's start with that. How can we reform our judicial system whereby people take total adherence, whether it's the law enforcement or the civilian, they take total adherence to court orders and court jurisdictions?
The premises of the court is a no-go area for any form of violence, any form of brazen executive lawlessness by agents of the government or any authority. The act of going into court to arrest somebody who the law enforcement agencies or authorities, alleged to have committed a crime whilst the court is sitting or within the compound of the court, attacks the sanctity and the independence of the court itself. It brings a lot of humiliation, shame, and embarrassment to the judiciary itself. And such, if the court decides to exercise its powers, will lead such officers and those who are above them who ordered such action, to face contempt charges, and they could be imprisoned for it. So, but in Nigeria, as you said, there has been a litany or a very, very inadmirable record of the executive or government authorities not obeying court orders. Well, this is contrary to the oath that every public official took to uphold the provision of the law and respect the sovereignty of the 1999 Constitution. So that it is a breach of the oath of office of any public official, whether a policeman, head of or member of the ICPC, FCC, customs, executive, legislature, to say that because a judgment does not bend or conform with their interests, that they are not going to choose it or in actual fact be cherry picking as to what part of the judgment they want to obey and what not to obey. These are breaches of their oath of office, which by provision of law would actually necessitate that those officials be removed from office for such a flagrant violation of the Constitution and their oath of office. But you find out that the checks and balances in our presidential system of government that stipulates that the executive, legislature, and the judiciary are co-equal branches of government that serve as a check and balance on each other by oversight function, administrative review, and even judicial review, are being circumvented due to partisan loyalty, where the Senate committee, the House of Representatives committee, have oversight functions over ministries, departments, and agencies and parastatals, and they refuse when there is a clear violation of the duty of a public official or an illegality committed to have a public hearing, do a sitting, carry out and then carry out a finding and recommend, because of partisanship and because of vested political interests, they tend not to do what they are supposed to do. And when court orders are made, the judiciary committee of both houses have a duty to ensure that ministries, parastatals, departments and agencies and their officials conform and comply with court decisions. And the implication is that anyone who does not can be removed, it can be impeached, and all manner of sanctions can be imposed to ensure that the rule of law is upheld. So, but you have different interests, and these different interests tend to behave in a manner that manipulates the outcome of the decisions of the judiciary, which is the final arbiter on issues between the state and the citizen, between the local government and the state, between the state and the federal government, and between the federal government and any citizen. So when somebody or agency, parastatal, ministry or department is not upholding judicial decisions, the effect is to lay the foundation for chaos, disorder, and a breach of the environment of lawfulness.
All right, thank you very much. Please, let's go on a short break, and when we come back, we'll continue with the discussion.
Welcome to the high side of life. Join us every day at High Impact 102.1 FM, your urban lifestyle station.
Money, I just want to be yeah.
Do you know bad production can kill a great content idea?
Do you want to have a photo shoot, audio production, or do you need a professional voiceover artist?
Do you simply want unmatched cinematography, video production, or just event coverage, such as weddings, birthdays, or burials?
Or do you need a space for meetings or conferences? All these are possible with High Impact Studios. Don't bring down your creativity, let's help you take it high.
And out of this world with our state-of-the-art equipment and first-class studio space.
We give you the quality you deserve at the best rate.
For more details, call 0706 393 5694 or 0915 958 1881. High Impact Studios, the future.
Tease your taste buds from a world of delectable choices. High Impact Planet. Fun just got real.
On record.
Every word matters.
Welcome back to On Record, where every word matters on High Impact 102.1 FM. You can also watch us live on High Impact TV on Iconsat 42 degree East. We are also live on YouTube, Facebook, and on X, formerly known as Twitter, at High Impact 102.1 FM. The phone line is still open. 0700 1021 1021 0700 1021 1021. You can also send WhatsApp messages to 0907 224 5018. We're still discussing unlawful detention and abuse of power in Nigeria, looking at the EFCC's denial of assault allegations with Bolanle Olugbani, a legal practitioner. Now, my question again now is, what role should the Nigerian Bar Association, kudos to the Nigerian Bar Association for swinging into action for this unlawful arrest and detention. Now, what role should the Nigerian Bar Association play in addressing alleged human rights violations by EFCC, not just for lawyers alone, but their clients also?
Well, the Nigerian Bar Association, is playing the precise role it was founded to play, and that is the defense of the rule of law and the due process and legality in our society, amongst other things. The Federal Attorney General, the state's Federal Attorney General and Minister of Justice, the state's Attorney Generals and Commissioners for Justice are all members of the Nigerian Bar Association. There are many lawyers, qualified lawyers, also working in the EFCC and indeed at the various law enforcement agencies and authorities all over Nigeria. So upholding the rule of law and legality ought not to be a difficult task if everybody played their role. By making a public opposition and resistance to the flagrant violation of the rights of a lawyer or a citizen, the Nigerian Bar Association is effectively engaged in advocacy to bring to the fore these alleged violations of human rights. And the Office of the Attorney General, both at the federal and at the state level, have a role to play, because the Attorney General of the federal and the states are empowered to take over a case. They are empowered to continue or discontinue. They are also empowered to initiate prosecution. So if there is no criminal charge against the individual who is being investigated, the legal practitioner or Nigerian Bar Association, they ask for the intervention of the state Attorney General or the Minister for Justice, the Federal Attorney General, and indeed the head of the agency, to intervene to ensure that this flagrant violation and this contemptuous act, against the jurisdiction of the court is not allowed to continue. We also have the National Human Rights Commission that plays a role in ensuring that human rights, its violation and the protection is made a compulsory national issue. And, in doing so, the National Human Rights Commission also has a role to play in intervening to ensure by supervision, by monitoring, by share advocacy and education and orientation of the law enforcement agencies as to what they ought to be doing for upholding and protecting human rights, and what they ought not to do as an act of abuse of power or acts that more or less, attack the rule of law and due process. So I think that the Nigerian Bar Association is on the right track. Pressure and opposition to flagrant human rights violation is just the first step, and liaising with every relevant authority to ensure the outcome is one that upholds justice for whoever is illegally detained in a manner as such as we are discussing, while a matter is before a court of competent jurisdiction, is the way to go.
All right, thank you very much. We can discuss about unlawful detention or illegal detention, but there's also prolonged detention. So, and of course, it's not just the EFCC alone. The police have been notorious in this particular field. So, I would like to ask, how can we reduce prolonged detention. I mean, just this morning there was a report on the papers. 6 NSAS protesters were released after 4 years. After 4 years, I mean, a panel was set up right after NSAS, and they made some recommendations and all. And 4 years after NSAS protesters have been released, even the recent N-Band governance protest, some people have been detained and they've not even been taken to court. How can the judicial system tackle this so that we have speedy trials, speedy prosecutions?
So the office of the chief judge of every state, has the power to engage in monitoring, supervision, and actual discharge of detained persons who have been detained without proper prosecution, or who have been detained for periods far in excess of what the Constitution prescribes. But the usual cause of this delay is the fact that the prosecuting agencies, whether the Nigeria police, or the customs, the DSS, the NDLEA, EFCC, file charges in court, and they, by so doing, engage the judicial process, and they now fail to, diligently prosecute, those matters, thereby leading to delayed trials, adjournments. Witnesses are not present for the prosecution of the defendant. The IPO has traveled or is on national duty. Series of adjournments, when in actual fact the person has pled guilty or not guilty to an offence maybe 4 years ago, as in the case of the NSAS, suspects or defendants. And because of that, they just continue to languish in prison. And when there's no diligent prosecution, usually the defense lawyers will make an application to court, which does not require any formal filing, just an oral application that the prosecution is not diligently prosecuting such matters, and so such matters should be struck out. That is, the person should be discharged, not on the merits of the case, but the fact that those who brought them to court for an alleged crime or offense are not doing what is legally and constitutionally, that they are supposed to do. And these are the powers that the judiciary can exercise. But the judiciary itself must be proactive and be less tolerant of these types of charges that are not diligently prosecuted, and not wait for 4 years before striking out such charges. In addition, they should also make an effort to scrutinize, some of the counts and the allegations or charges made in the charge sheets, to see whether there are factors that necessitate or make those charges incompetent or invalid, and take appropriate action. The Legal Aid Council, the Office of the Public Defender, that is for Lagos, the Office of the Public Defender and Legal Aid Council should do more to provide pro bono lawyers for such defendants who cannot afford to sometimes they deem to be expensive legal services in engaging private legal practitioners, to defend their cases. And so lack of a legal representation for defendants, even though the Constitution says you can't be defended by a lawyer, you can't defend yourself, also makes, these types of illegal and prolonged detention, in a prison or custodial facility, longer. So these are the factors that are militating and causing, the issue of these types of detention, which the Constitution does not allow. And charging a suspect or defendant to court should not be a way of punishing the person when you know that there is no credible evidence against such persons. And the law enforcement agencies must also play a role that does not give the impression that they are out to prosecute instead of prosecuting. And their actions should not be that which makes prison congestion, which is at a very, very terrible rate in the country, even worse.
All right, I think this is a perfect place to a safe place to land. Thank you very much. I do appreciate your thoughts on this particular issue, and we do hope to hear from you again.
Thank you.
You're welcome. This is where we will draw the curtains on record this morning. We have been talking with Bolanle Olugbani, a legal practitioner, and he has spoke length on the topic unlawful detention, abuse of power in Nigeria. Many thanks for those who tuned in. Many thanks for those who watched us. Let's do this again next week, same station and same time. I am Olumide Shokoya. Good morning.
Welcome to On Record.
Every word matters.
What I want to do is to take Nigeria from consumption to